Welcome to our second presentation covering ERISA, HIPAA, COBRA, and other benefits laws. So let's begin. In our first lecture, we covered the Employee Retirement Income Security Act, more commonly referred to as ERISA. And so now in this presentation, we're going to cover the Health Insurance Portability and Accounting Act, which is usually called HIPAA. And now we have the Affordable Care Act, which is formally the Patient Protection and Affordable Care Act, oftentimes called, well, Affordable Care Act, or ACA, also called colloquially Obamacare. And finally, we'll talk, well, not finally, but we'll also talk about COBRA, which is the Consolidated Omnibus Budget Reconciliation Act. And then there'll be a few other aspects of these laws that we'll talk about in more detail. So let's get started. I'm going to fast forward to the section where we left off at the end of our first lecture. So here we are, and we're up for HIPAA and Obamacare. So what is HIPAA? Well, it's a statute that is designed to kind of do two things. First of all, it was initially planned to protect employees who transfer from one job to another, but who have, or a member of their family might have, a pre-existing condition. Prior to HIPAA, it was possible for such an employee to find it difficult to transfer because when he or she goes to work for the new company, that company might have a very nice health insurance program, but it may exclude pre-existing conditions. What would happen then is that the employee felt unable to change jobs. And even though that job may not have been a good fit for he or she or the family, but because of the fact that this pre-existing condition exclusion was causing it difficult for him to find positions where he or she would be able to continue the health insurance. So that's a major and important factor about HIPAA. It is true that the Affordable Care Act also addresses that issue and precludes pre-existing exclusions. So in other words, it doesn't allow employers to exclude pre-existing conditions. HIPAA did not absolutely prohibit it, but limited it significantly. I'm talking about this aspect of HIPAA, though, because the Affordable Care Act, in part because of its controversy, because of opposition that exists on a political basis to this law, it's not clear exactly what its long-term kind of destiny is going to be. It could be repealed or significantly amended or changed or enforced in a different way so that some of the protections that were initially planned for it aren't necessarily going to continue to be in effect. And so if we lose certain aspects of the Affordable Care Act, we may go to HIPAA and see that those aspects of HIPAA may become more important. Most of us, though, when we think of HIPAA, think about the privacy protections. And so we'll talk about those in a minute. But before we do this, let me mention this. Lots of companies have wellness programs associated with their healthcare plans. These programs have not necessarily been proven to be that effective, but I guess the hope is that the one that is being designed by this particular company is going to kind of beat the odds and is going to be effective. And examples of these type of wellness programs are oftentimes focused on people who have chronic conditions such as diabetes or maybe a heart condition, or perhaps somebody who is outside of the ideal weight range for the height of this person. Also, these programs can be focused on smoke cessation or things along those lines. The intention is oftentimes good, the idea being when this person receives more support, more assistance, he or she may be in a position to make health choices that will improve the prognosis for this particular person. Another category that's often used for this is when somebody is expecting a child, and so they're given coaching or assistance in maneuvering through the various health issues that may come up as pregnancy progresses. As I said, that the results have been mixed with these types of programs, but whether a particular program is successful or not in terms of managing healthcare costs and managing the health of the employees, there can be issues with non-discrimination aspects of HIPAA and also privacy aspects of HIPAA. So these items have to be carefully managed to make sure that no lines are crossed in these areas. Okay, so let's talk about Mary. Mary's been diagnosed with a serious illness and she needs to undergo surgery. 2 months before this diagnosis, she began to work for her new company, which had a 3-month waiting period before any new employees can enroll in the medical insurance plan that the company offers. If Mary enrolls in the insurance at the earliest possible date, which will be in a month, she will be eligible for coverage because employers are prohibited from excluding employees from insurance coverage due to a pre-existing condition. Mary may or may not be able to wait until then, but if she can, Eager Beaver plan will have to cover Mary under those circumstances. I said before that one of the things HIPAA is designed to do is to protect the insurance coverage for workers and their families upon a change in or loss of employment, again, that pre-existing condition scenario. But it's not, but the other benefit, of course, is the specific requirements that healthcare providers, insurance plans, and to some extent employers have to follow with respect to the privacy of employees' health data, and not just employees, but other aspects. And of course, HIPAA is actually an amendment to ERISA, and let's see here, the individuals whose private health insurance is revealed, however, though, do not have a claim of action. They cannot sue because of the revealing of this information. There is no private cause of action. For example, we saw that same standard in the OSHA statute. The individual will have to seek redress through the governmental agency. And for the most part, the governmental agency isn't going to be giving the employee any kind of benefit. If there's a fine paid, it's not going to the employee, it's going to the government. That doesn't mean, though, that the individual is out of luck because his or her privacy information or confidential information was revealed. He or she may well be able to assert a tort claim under state privacy law. And so that could be an avenue for potentially significant damages under a state law claim, but the employee would have to be the one to advance that claim. The governmental agency isn't going to be responsible for advancing that one. Let's consider this scenario. Mary is the chief administrator in charge of medical records at a local hospital. She receives a request for copies of Bob's medical records from Bob's employer. Mary releases them without Bob's approval, which is, of course, a HIPAA violation. Under these circumstances, Mary has violated HIPAA's privacy rule because Bob's employer is not included in the category of who can receive protected health information without authorization from Bob. One of the things that I want to mention is that many employers have been very intimidated by HIPAA. For the most part, HIPAA has to do with what doctors and hospitals and health insurance providers can and cannot reveal. In this scenario, Bob's employer was not entitled to these documents, but the act of asking Mary to provide them was not a violation of the statute. Bob's employer shouldn't have gotten the records, but under this scenario, Bob's employer did not violate the law. Mary, and through Mary, the Collin County Hospital violated the law. While it is possible for employers to violate HIPAA, and certainly by sharing information about Bob, the employer may well be violating the Americans with Disabilities Act, for example. But usually violations or breaches of the privacy requirements of HIPAA aren't going to be on the employer's back, but are going to be on the doctor's back or the hospital's back or the insurance company's back. Okay, so now let's turn and talk just a little bit about the Affordable Care Act. This, as you know, was passed in the early days of President Obama's presidency in 2010, and it's been controversial throughout his presidency, and now that his presidency has ended, it remains controversial. It may well be amended, underfunded, repealed, or enforced in lots of different ways, so it's difficult to know exactly where this is going to come down in terms of kind of its lasting effect. Here's some general information about the statute, so I'm not really going to go into details because we're not quite sure what's going to happen about it. Now let's talk about COBRA, which of course stands for the Consolidated Omnibus Budget Reconciliation Act, which is a mouthful. I don't expect you to know this name. We are going to refer to it simply as COBRA, so that is the easier way of talking about it. Don't think that many legal professionals actually know what the full name of the statute is. So COBRA requires that employers provide employees with the option of continuing their health insurance when qualifying events happen that would otherwise terminate coverage. So examples of those events could be a voluntary or involuntary termination of employment. Now, with respect to this one, there is a little bit of wiggle room here. The statute says that when the employee was guilty of gross misconduct, the employer does not have to offer COBRA benefits. I've worked for a very large employer, and there certainly have been lots of examples of gross misconduct because there were so many people employed by the company. And I had never heard of my employer ever saying we're going to take advantage of this gross misconduct option. I think it would be unusual for an employer, even in cases of theft or other actions, to actually say, no, we don't want to extend COBRA benefits. For one thing, COBRA benefits are not expensive for the employer to provide. And so by declining to give COBRA benefits to the employee, you face the possibility that the courts wouldn't agree with you that in fact that there maybe wasn't gross misconduct. And you also put in jeopardy the employee's entire family because many times they are receiving insurance as well. So yes, there is this out, but I don't think it's very commonly taken even when gross misconduct is present. We can see that the employee is eligible for COBRA benefits whether he or she resigned or was terminated. Sometimes a reduction in hours can cause an employee to lose benefit status. Perhaps the employer requires, averaging 30 hours or 35 hours or 25 hours a week or something. And when an employee's hours are dropped, again, either because the employee has made this choice or the employer has made this choice, that may cause the employee to be eligible for COBRA benefits. If the employee loses his insurance coverage, he's entitled to COBRA benefits, even if he or she continues to be employed by the company. Another situation, this isn't really going to apply so much to the employee, but to the employee's family. If the employee divorces or experiences a legal separation, then the spouse is entitled to continue under the COBRA benefits. In fact, in this case, for most of these categories, the benefit will continue for 18 months after the end of employment. And then the last one is 36 months. In the case of divorce, the former spouse of the employee can continue COBRA benefits for up to 36 months. Obviously, with the death of the employee, the family, if the family were receiving insurance through the employee, they would be permitted to continue it for 18 months. The loss of dependent child status often occurs when the child is old enough to graduate from college or nowadays at the age of 26. And so this gives the child a few more months to, find employment with insurance or some other benefit. And then another situation is if the covered employee becomes eligible for Medicare benefit. He or she can choose to, because usually when this happens, the employer will make the employee no longer eligible for the health insurance plan that the employer offers. Into those situations, it's possible that the employee will want to continue health insurance, especially if he has or she has a spouse who is not Medicare eligible or has children who obviously are not going to be Medicare eligible. COBRA applies to the same group of employers that the ADEA applies to. You may recall under Title VII, the threshold is 15 employees. But under the ADEA, it's 20 or more employees. And so if you have fewer than 20 employees, you could still have a program that provides ERISA benefits, but you don't have to offer COBRA into those situations. The 20 is the threshold where you have to start offering COBRA benefits. Continuation is not free for employees under those circumstances. In fact, the employee who elects to take COBRA is going to pay 102% of the cost. So he's not just going to be paying the total cost, but also an administrative fee of 2%. Let's consider for a second some premium numbers. I'm just going to kind of randomly pull these out. Let's say an employee is just or is providing insurance for his whole family, and so his part of the premium is $300. He pays this every month. His employer pays $600. That's a pretty common shift. Usually the employer pays about 2/3 to 3/4 of the premium, but usually the employer doesn't pay quite as high a percentage for the family members. So this is a pretty representative number here. So you can see the total premium in this situation is $900. As long as the employee is employed, the employee is going to pay this much. But once he loses insurance, either because the employment has ended or perhaps because he's lost his benefit status, he's going to have to pay this amount, but not just this amount plus 2%. So that would be $900 plus 102%, which would make it he would be paying $918 each month. You can imagine somebody who's lost his job or has had a significant decrease in his hours, who's used to paying $300 is now paying over $900, even though the option of COBRA is available to this person. Many times it will just be too expensive for this person to participate in. But it is an option, and perhaps this would make sense in some cases. As I said before, in most circumstances, the employee, if he elects to participate in the COBRA option, is going to have it for up to 18 months. But again, in the case of a divorce, the former spouse of the employee can continue for 36 months. So let's talk about a few related concepts. The first, we're going to talk about the Older Workers Benefit Protection Act. We talked about this in the Age Discrimination in Employment section. We talked about that particularly with respect to releases, what needs to be in the release that an employee over the age of 40 might be signing to waive certain claims that he might have to age discrimination. And we talked about what the things have to be in that release for it to be enforceable. Let's talk about some other aspects of the Older Workers Benefit Protection Act. This permits employers to provide less extensive coverage for older workers as long as the employer is spending the same amount as it's spending on other workers. The fact is that older workers typically use health insurance more extensively. They experience more health problems. And so the premiums that would be related to a worker, say, who is 50 years old would be greater than those for a 30-year-old as a statistical basis. Obviously, an individual 50-year-old may not use health insurance anymore, may even be less than a 30-year-old. But as a generalized perspective, it's going to be higher. So it's okay under those circumstances under the statute for the employer to provide fewer benefits for that 50-year-old worker, but at the end of the day, the cost has to be no less for that 50-year-old worker. This applies only to welfare plans, and you may recall we talked about this. These are the non-pension plans that qualify as ERISA plans, so things like health insurance, disability insurance, life insurance, those types of things are welfare plans. Under the Older Workers Benefit Protection Act, there isn't an option for the employer to pay fewer benefits to the older worker. We talked about this also in the ERISA section, but let's just do a refresher on this. Employers may not refuse to hire or terminate a disabled person because they're going to be more expensive to insure. That can't be a factor in the decision. Let's talk about QDROs. This is an abbreviation. It's pronounced quadro, but it's kind of more like QDRO, I guess, but for whatever reason we don't pronounce it that way. It stands for Qualified Domestic Relations Order. It's pretty common when a couple divorces that one of the big assets sometimes is the benefits that one of the members of the family have access to. It could be a pension plan, it could be a 401k, it could be a defined benefit program, and under those circumstances, that may be a big asset in the marriage, and so it makes sense to use that as one of the things that can be divided. But a tricky point with this is that usually the employee doesn't have access to his 401k or to his pension plan until he reaches a retirement or she reaches a retirement age. This divorce might be happening at age 30 or 35 or 40, well before this particular employee would be eligible to access the account. And so under those circumstances, you kind of got this problem. You need to access the money in order to distribute the assets that are part of that marriage relationship, but the plan itself prohibits that type of division. Well, the way to get around that is for the judge to issue a QDRO, a Qualified Domestic Relations Order. And this order from the court, it would be directed to the plan administrator for whatever that plan is, and that would override any no severability provisions in the plan, and that therefore would allow the plan administrator to divide up the assets in that particular program as is ordered to do so by the family law court. So this is a relatively common thing that needs to happen in divorce situations. Not every divorce, but a very common arrangement that needs to happen from time to time. At this point, we've gone through all of our topics for this particular chapter. Again, we didn't do a very deep dive on any one of them because these aren't topics that the average HR manager or employment law paralegal necessarily has a lot of direct responsibility for. Nevertheless, it's important that you have some understanding of the issues, and if your practice takes you or your professional life takes you to be in more depth in these issues, there's certainly a wealth of additional information to learn for mastery. Obviously, it's very important that the employer continue to comply fully with ERISA, also COBRA and HIPAA. In fact, all the laws in these areas. Thank you for your attention. At this time, we're concluding this particular chapter. As always, if you have any questions about the material, please don't hesitate to reach out to me. My email is cgroover@collin.edu. I'd be delighted to hear from you. Or better yet, stop by my office hours, either my virtual office hours or my face-to-face office hours. Give me a call or come by. I'd be delighted to talk to you about any of these topics. Thanks so much for your attention, and I hope that you have a wonderful day. Take care.